Hello, ladies and gentlemen. The issue I'd like to discuss with you today is the Supreme Court decision that came out last month that effectively struck down the Defense of Marriage Act, referred to as the DOMA Act, and its effect on U.S. law, U.S. immigration law, and in particular, U.S. immigration law as it applies to Thailand, since our office is located in Thailand. Now, by way of background, the Defense of Marriage Act had the effect of federal law would only recognize marriages for the purpose of federal benefits, provided that the marriage was a heterosexual marriage. Therefore, if you were from a state, or if a same-sex couple was from a state that allowed legal gay marriages, then the federal government would not honor that legal decision by the individual U.S. state, but would instead apply federal law for the purpose of federal benefits. Now, this led to the paradoxical situation that a same-sex couple can be from a state and be legally married, but the marriage would not be recognized by the federal government for the purpose of certain laws and benefits. The Supreme Court decision came down last month, and it had the effect of overruling the effect of DOMA. The result is, if you're from a state, or if a same-sex couple is from a state that allows for same-sex marriages, that you're entitled, or the same-sex couple is entitled to the same federal benefits that a traditional marriage, a traditional couple that was not same-sex would also be entitled with. Now, this is going to have sweeping and dramatic changes throughout the legal system. It's going to have changes with regard to divorce law, matrimonial law, family law, benefits law, pension law. But the issue that we're discussing today is immigration law, U.S. immigration law. Traditionally in Thailand, when we've dealt with same-sex couples who wanted to immigrate to the USA, we would have a problem. Because even though the petitioning U.S. citizen might be from a state that allows gay marriage, that petitioner, U.S. citizen petitioner, would not be able to petition for his same-sex spouse or a same-sex fiancé as a result of DOMA. That's no longer the case. Currently, if you're from a state that allows for same-sex marriage, you should be entitled to all the benefits under U.S. immigration law that a traditional couple has been entitled to. This includes petitioning for a marriage visa or for a fiancé visa. Now, if you're a petitioning U.S. citizen who's petitioning for a same-sex partner under a marriage visa or a fiancé visa, but your state does not allow for same-sex marriages, you're going to have a problem, particularly with regard to fiancé visas. With regard to fiancé visas, the test is going to be whether the state of the resident petitioner, who is a U.S. citizen, allows for gay marriages. Since Thailand does not allow for gay marriages, we expect that there's going to be much fewer marriage visas based on a couple where the U.S. petitioner is petitioning for a spouse from Thailand than in cases where there's a fiancé visa, because the only requirement should be that the U.S. petitioning spouse is from a jurisdiction in the U.S., a state in the U.S. that allows for gay marriages. Now, we're expecting that this is going to create a great deal of cases, many new cases from people that were previously ineligible for fiancé visas, but now are currently eligible for fiancé visas based on the new Supreme Court decision. In fact, Janet Napolitano, the head of the Department of Homeland Security, has specifically issued an instruction or directive to the USCIS to direct the USCIS to conform their practices in accordance with the new Supreme Court decision. In the practical situation, however, we do not know if there are going to be any roadblocks or obstacles to processing fiancé visas for same-sex couples, provided that all the other requirements are met. This is because there have been no specific regulations issued with regard to same-sex marriage couples or fiancé visas from the USCIS as yet. So in theory, everything looks good to go. In practice, we're not totally certain. There might be another case that develops based on a denial of a same-sex visa, and the issue might have to go up through the appeal channels to get a final decision on the matter. That's how it stands right now. At any rate, the striking down of DOMA by the Supreme Court is a significant victory for same-sex couples, and if everything works out right, this should open the door for allowing your same-sex partner, fiancé, to receive immigration benefits to the U.S. That's all we have for you today. We thank you very much for watching.